So, hi, one and all. I hope you're all doing well and keeping safe during these tough times. So, after a brief conversation with Sukunda sir, I decided to address the students of SLS Nagpur just by introducing what international commercial arbitration is. I know that the lecture was titled Fundamentals of International Commercial Arbitration, but the fundamentals of international commercial arbitration itself is quite broad and it's an ocean in itself. So I thought, keeping in mind that most of the students are at a very early stage, probably first to second year of law school, it is necessary that you understand what arbitration is. And after explaining to you what international arbitration is, I will jump to the international commercial arbitration part of it and quickly show you how the process takes place, and then I can address any of the questions that you have, either careers in arbitration or anything in depth about arbitration. And I also have an exercise in between my address to you, and I would love that everybody joins and makes this a more interactive kind of a session than a monologue by my side. Can you change the slide, sir? Yeah. So broadly, there are two main dispute resolution methods. I'm sure that most of you by now are aware of this. And there is national court litigation, and where you approach the courts, where many parties or two parties approach the court to and rely on the state mechanisms to resolve the dispute. And alternatively, there are the ADR mechanisms, which is the alternate dispute resolution mechanisms, which are methods of the court, completely or not completely independent of themselves. Can we change the slide, sir? Yeah. So these are some forms of ADR which are quite prominently used. As you can see, first is arbitration. The second is expert determination. Third is conciliation, mediation, and negotiation. I'll just briefly point out about all of these ADR mechanisms. Arbitration will be explained further to you. Expert determination is a form of an ADR mechanism where, in cases of complicated disputes, where it goes beyond the understanding of lawyers, where you need an expert to sit and determine. For a small example, let's just take construction or engineering disputes or maritime law disputes where calculation of costs or to understand the gravity of the dispute, you need experts to determine as to the elements, as to the nature of the dispute, because lawyers cannot sit and quantify maritime values, or let's just take construction engineering uh, elements of that. So you need experts to determine all of that, whereas lawyers will sit with them or arbitrators will sit with them and determine on the legal aspects of the dispute. Then we come to conciliation. Conciliation is a form of method where two parties sit together and basically appoint a conciliator, and it's not as binding as the other forms that like arbitration, but it's one of the ADR mechanisms where both the parties have to enter into a dialogue to come to a resolution. Then we have negotiation. Negotiation also is quite popular, and it's also used as a pre-mechanism to arbitration, where two parties agree to negotiate and resolve the disputes among themselves before heading to arbitration. And this is quite popularly seen in the international context as well, where parties really want to save time and not get into a small ego dispute and spend lots of money on arbitration or litigation. Hence, most of the arbitration clauses have uh, a pre-clause of negotiation where they agree to resolve the dispute within 30 days through the process of negotiation. And if that fails, then they proceed to other mechanisms like arbitration. Or also court litigation. Then we have mediation, which is quite popular again, especially in India. Here, the parties appoint a mediator, which is a neutral third party. So the mediator's job here is not to make an award or a judgment, but just to facilitate discussion. Both the parties come on the table, and the mediator just allows them to speak in a dignified and an amicable manner so that they can come to a conclusion on the dispute. Can we go to the next slide, sir? Yeah. So good comparison of these ADR mechanisms can be seen through these four factors as to why people want to choose each one of them. As you can see, there are four main factors: presence of a third party, proposal of a solution, whether it's binding, final, and enforceable. As you can see, arbitration has ticked all the boxes, and negotiation is not. So, according to the gravity of the dispute, or according to what the parties really want, you can tailor your dispute mechanism by a mixture of these alternative dispute resolution methods. So, for example, you can have, like I said earlier, you can have a negotiation or a conciliation before you proceed to arbitration, which is much more formalized. So, in case of negotiation, two parties can sit together with their own managements or teams, respectively. And that's why there is no presence of a third party here. There is no proposal of a solution by a third party, like in the case of arbitration, where the arbitrator will award a judgment to you. Here, you have to come to an amicable solution by yourself. Negotiation is not binding, like expert determination or arbitration. You don't get a final award. It's basically understanding that you come between yourselves. So you draft an MOU after you finish, after the negotiation is successful. Then the finality and enforceability, which is very, very important. You can see that apart from arbitration, the rest of all the ADR mechanisms are not enforceable and final. They can be revoked. So most of them, the result of most of them, apart from arbitration, are just contractual tools where you come out and you have a MOU and you just have to enforce that. There is nothing else apart from it. Unlike in arbitration where you get an award. Can we move on to the next slide, sir? Yeah, so what is arbitration? Arbitration, I'm sure most of you might have heard this term, might have come across, or also might have read about it. So arbitration is essentially, I wouldn't say it's a very simple method. It's become quite complex over the couple of decades now. But in brief, it's an out-of-court dispute resolution mechanism. It's much less formal. And basically, both the parties use a contractual mechanism, which I will be explaining further, to enter into arbitration, where they invoke this arbitration clause and approach an individual or a group of individuals or an arbitral institution, which are the arbitrators, and they decide on your dispute. It's more or less similar to a court hearing, but very less formalized. So you present your arguments in a similar way. You have evidence collection. You have the examination of witnesses. Everything's pretty much the same, but it's in a less formal manner. It's more tailored to your requirements, and it's short and effective. So it's much more easier than going to courts because courts are highly regulated, and arbitration is, like I said, you can tailor how much regulation you want in your arbitration process. Can we go to the next slide, sir? Just a sec. I think we have a. Okay. I think Kaushik says that he did not clearly understand the difference between conciliation, expert determination, and mediation. Yeah, so all three of them have a tad bit of difference between them. So mediation is where, start off by mediation first. Mediation is where two parties appoint a mediator. So there is a sense of involvement of a third party, a neutral person or a group of persons. And in respect to conciliation, that can or cannot be the case. It depends. But mediation is more like where, two parties approach this person not to give an award, but to just facilitate the conversation. Whereas conciliation is a bit different. It's more like negotiation where parties have to come to determination without the third party. So the difference here is the role of the third party. The third party in conciliation, which is the neutral party that you appoint, the conciliator, is not responsible completely for facilitating. He does not promise you that if you come to me, I will resolve your dispute. His job is just to make sure that the two parties act in a sane manner and try to resolve the disputes amicably. So, conciliation by itself, like the literal meaning of conciliation is stopping someone from being angry, like conciliating a dispute, right? So, it is also a form of mediation in certain ways. It has been argued that way, but it is not completely mediation as an ADR form. And then expert determination is quite different, where you appoint an experts with a body of arbitrators or conciliators because the dispute has an element of technicality. So you appoint an expert so that he can decide on the areas of technicality. Like I quoted in my example, let's say a construction dispute. You don't really know what goes into the civil engineering aspect. So you want a civil engineer on your mediation panel or on your arbitration so that they can sit and decide on the technicalities and give out a fair judgment, not really a judgment, but give out a fair idea to the lawyers and to the parties that look on the technicality, what he's saying or what that person is saying is right or wrong. I hope you understood the difference now. Perfect. Can we go back to the previous slide? Yeah. Like Redfern and Hunter have quoted, arbitration is a short, effective way of obtaining a final and binding decision on a dispute or a series of disputes. So this definition has keywords which are particular issues in themselves within the field of arbitration. So arbitration is short, which is disputable. Arbitration is effective, which again we see later in the presentation that it's primarily the efficiency because of which arbitration is flourishing. But is it all that efficient anymore? We'll be seeing that further. It's final and binding, which is the most important, and that's why it's taken a shoot among the other ADR mechanisms. And without reference to court of law. So arbitration, I would say, yes, stands alone, but it is not completely independent from the involvement of courts. So it's a quite common misconception among people who do not really understand arbitration as a procedure. They look at arbitration as something very standalone from the court involvement. But arbitration will not stand in itself if there is no court involvement in it. Because ultimately, what the award or the judgment you get from an arbitration has to go back to a certain country or has to go back to a certain state, and only then will that be enforced, right? And how will you enforce it? It's only by the courts you're going to enforce that. Can we go to the next slide, sir? Yeah, these are a few advantages of arbitration. And so primarily when I started studying arbitration, for me to keep a check of what the advantages are, I followed the 3E rule, which is arbitration is expedite, arbitration is efficient, and arbitration is enforceable. So these 3E advantages of arbitration are the primary base of selling this process to the commercial world as such. But the other advantages are that it's impartial and fair. that so how arbitration works is when two parties appoint an arbitrator, they want a neutral arbitrator, an impartial arbitrator who's fair, who doesn't know the parties. So only then the element of justice comes in, right? Because there is no biasness here. Sanjana, sorry, I'll just take this question after completing the advantages and disadvantages. Then the dispute will normally be resolved much sooner than litigation. Like we see how complex commercial litigations take a toll because of the slow court processes across the world, not only in India. So arbitration is quite tailored for that. So you have your own arbitral tribunal that you appoint for yourself, and they sit on it and they make a schedule that yes, within 90 days we will resolve your dispute, and this is how it's going to be done. And in a month we will have so many hearings for you. So it's much more faster than the normal court litigation. Arbitration can be like I put can in quotes because it's quite disputable to say that arbitration is less expensive. It's turned out that arbitration is expensive now, especially in an international commercial setting. It can get more expensive than courts. But overall, what the statistics say that if you compare the arbitration process to the court process, the overall cost of it is much lesser in arbitration than in courts, but depends on how you tailor your proceedings and how much time you require, and also depends on the opposite party. So if they stop uh, coordinating or cooperating with you in the whole process, you just have to keep paying bills to your arbitral tribunal, the arbitral institution, to your lawyers. And also there is a risk of, if you lose the arbitration, you'll have to award costs of proceedings to the opposite party. So it can get quite expensive. But primarily, many disputes which are much more simpler, which are not very complex, can be resolved faster. And in that sense, it becomes less expensive. Private procedure, like I said, it's a mix and match of rules and procedures. You can have substantive laws, and you can have procedural laws of two different places. You can mix and match your procedures. You can choose a place where you want to arbitrate. So let's say if I am an Indian party and I get into a dispute with a Sri Lankan party, I head to London to arbitrate because I know that the rules, the English arbitration rules, are much more simpler, much more clear, and I can get a better award, a much more enforceable award from England than arbitrating in India. That's where the whole concept of international commercial arbitration comes in, where people choose neutral jurisdictions or neutral seats as such to mix and match rules and procedures. Then we have a binding and final award, which is one of the most important aspects of arbitration, where after the whole process, after the whole proceedings take place, finally it's on the arbitrators to sit and decide, come to a consensus as to give an award which is final and binding. We will see later in this lecture how the award has become how it becomes final and binding, and what's the reason and which laws are behind the award being final and binding. And the last part, I think this is the most important advantage of arbitration currently and has been in the past: confidentiality. I mean, if you are two big companies who are litigating, or let's say who are going into an arbitration, you don't want your matter to go public. And why would that be? I mean, just imagine that. Let's say if Apple enters into a dispute with Samsung, everybody is reading it. Their share prices fall, their sales fall, or if Apple has done something very blatant and it's being litigated in courts, it's open to public. Everybody can read it. So that's the reason these big companies and these big transactions have arbitration clauses in them. They rely on arbitration mechanisms because they resolve the dispute confidentially, And so the whole thing with confidentiality is it's not only to protect them from their competitors or market forces, it's also to protect reputation. I mean, a business builds its reputation and goodwill over a period of years, and they don't want to lose that over one dispute which is made public. And so this process keeps everything confidential, and that's one of the major advantages. And you see why parties adopt this method. And it's very rare to see that arbitration awards or arbitration proceedings are published or are given on record, because parties themselves are not comfortable for it. Though there are mechanisms that if you are comfortable as a party in an international commercial setting, you can publish or uh, make your proceedings on record. And there are many actually. So if you are very keen to see how an international commercial arbitration works, you should just YouTube it, say International Commercial Arbitration Proceedings. You'll get many proceedings which have been uploaded on YouTube, and you can get an essence of how it looks like. Can we move on to the next slide, sir? So what could be the disadvantages? After all, like it's not all great and fancy and glory. It's just being glorified. Can anyone jump in and tell me, or at the top of the head, what do you think the disadvantages of arbitration are? Anyone, even in the chat box, just feel free to type something. I'll wait for about 15 or 20 seconds, then I'll just tell you about it.
Excuse me, sir.
Yeah.
I think they give up their right to appeal because the decision is binding and final.
Yeah. That's
So
absolutely right.
that could be a big disadvantage.
Yes, absolutely. Any other disadvantages that people can think of? All right, I just say, yeah, that's right. That's one of the major disadvantages, that there are no appeals to an arbitration award. Although you can challenge it, so you have to understand the difference between an appeal to an award and a challenge to an award. So an appeal to an award is more like, so how in courts, from a low court you go to the high court to appeal the decision, and from the high court you go to the Supreme Court to appeal the same decision, right? But within the arbitration setting, once the award is passed, it's final and binding. There is no more appeal to it within the arbitration setting. But if you think the arbitration goes against public policy, or you've received the award through a fraudulent measures or something like that, then uh, then you can approach the court and challenge it. And then the major disadvantages is also on cost. Like I said, it can be less expensive, but in an international commercial setting, it's not all glory about how arbitration is cheaper, but it can get quite expensive, because once you approach arbitral tribunals, or let's say if your dispute is of a couple of $1 million, you don't want your dispute to be resolved by junior lawyers like me, right? You want senior arbitrators sitting on the panel and deciding. So these arbitrators have a certain charge. They charge you per hour or per meeting. And so it all depends on how cooperative the parties are, like I said earlier. And it can depend on which jurisdiction you're arbitrating in, because it has to be convenient for arbitrators to fly in, for the parties to fly in one particular jurisdiction. So all that taken into consideration, it can be quite costly. Then the third disadvantage could be that there are no rules of evidence. Like, for example, in Indian courts, you have the Evidence Act, you have the limitations, all of that. Then you have the procedures. But in case of arbitration, there are no rules of evidence. So as of now, there is only the IBA rules, which is again a soft law, it's not binding. And it's just a mere guidance. It's just showing you the norm. It's not really enforcing, or it's not binding on the parties that you have to have this particular rule of evidence, or this is the limitation to you. So that could be a major disadvantage, because uh, by hook or crook, the opposite party or the other party could make use of these mix and match of rules for its own favor. That can go against the process of arbitration or the efficiency of arbitration. Then there is lack of consistency. Like you see, for example, if you have a commercial matter at the NCLT, for example, there are a set procedures, right? Then there are set mechanisms. Uh, I'm so sorry. I'll just take Sanjana's question a bit later after this, and I think there are other questions as well. Uh, yeah, I was at the point where it's not very consistent. Like, you see, court processes are quite consistent. You can make out of how it's going to be like. You know that when you file a writ, this is the first thing you have to file. You have to file a caveat. Have to do all of that. There's a set rules, a set procedures. But in arbitration, it's not very consistent. Like, for example, you can have an arbitration in London, which can be a bit different from an arbitration in Paris, which can be a bit different from an arbitration in Singapore, because their respective national laws. So the national law of the seat is where the arbitration takes place, or where the parties agree to arbitrate in a neutral jurisdiction. So that's your seat. So their national laws and the institutions regulations. For example, most of you must have heard of SIAC, or most of you must have heard of London International Arbitration Center. So all of these have their own institutional rules. And this is what makes it non-consistent, because so primarily, uniformly, it is a consistent process. Like, when you look at it from outside, it is quite consistent. But there are just minute details and minute rules within these domestic laws, within these institutional rules, which kind of make it different. So I can just give you a small example here on consistency. Let's just take the popular debate on arbitration, the civil and common law, where the French look at arbitration as quite transnational, and the English or the common law countries look at it as a very domestic matter. So in terms of, let's say, I will tell you about consistency in terms of court involvement. So the French do not believe that the court should be involved from the very first step. So if you're arbitrating, if two parties go for an arbitration in France, the court will not involve at all in the very beginning. Even though you're approaching the arbitration in a wrong way, the court will say, no, it's on the arbitration tribunal to decide. And once they have taken the decision, you can come to us later and then come up with your grievances. But whereas in England, it's quite different. So if, let's say, if the arbitration agreement is not consistent, you can approach the court at the very stage of enforcement of the agreement and approach the court saying that this is not a valid agreement and we should not be arbitrating. And the court will look into the matter. And if it is not consistent, then the court will stop you from proceeding into arbitration, or the court will force you into arbitration. So there you can see that there is a lack of consistency in an international context between various jurisdictions, how they follow or how they look at arbitration, if they're arbitration friendly or not. So all that can act as a disadvantage. Then arbitration is not public, like I mentioned, it's confidential, and that can act as a disadvantage as well, right? Because these major parties like Apple, Google, and let's just take these major corporations who have such a big role to play in our lives. They have a corporate social responsibility. And by entering into arbitrations, they make these proceedings completely confidential. So you don't know what's happening behind the veil of arbitration, right? It can be quite dangerous because the whole concept of justice is that the public needs to be informed. There is a role of public involvement, there is a role of public interest. And that's when, because it is not public, because the nature of arbitration is such, that's when the whole restriction to arbitration comes in. So there are certain matters which cannot be arbitrated. Let's just say family matters or criminal matters where the public interest is quite high. You cannot take these matters to arbitration. Then the other disadvantage could be that there are various problems at the enforcement stage. A popular example, a recent one I can give from India is of the Ranbaxy and the Daiichi judgment, where these two pharmaceutical companies arbitrated in Singapore. And when Daiichi got the award against Ranbaxy, which is an Indian company, they came to the Indian court. And I think they're still fighting. It's been more than 5 or 6 years now that the matter is still going on in the Supreme Court of India. So that's where the problem comes. How arbitration friendly a jurisdiction is, or how willing a country is to enforce the award without looking into the crux of the matter. So, for example, if you come with an award, let's just say if you arbitrate in London and one of the parties is from Paris and he's the award winner and he goes back to Paris and wants to enforce it, unless there is a blatant violation of any public policy or any laws, the court will not look into the matter. The court will merely enforce the award in a very straightforward manner. So I think these are the common disadvantages that you see on the face of it. And I mean, it's a very complex niche, arbitration. It's a very complex sector. As we keep unpacking arbitration as a procedure, you can see that there are complexities at every stage, and I will deal with this in the end. And we move to the next slide, sir. Yeah. So after all that I've said, how do you think that arbitration as a procedure is introduced as a mechanism? How do you think it is introduced? Like I said, it's quite distinct from the courts, right? You don't have to file a complaint, or you don't have to file a writ, or you don't have to file a motion. So how do you think arbitration is invoked? Anyone on that?
So if there is a dispute regarding any matter in the contract, the parties will then resolve to the arbitration as given in the contract itself.
Right, that's absolutely right. So it's primarily, it's very important to understand that arbitration is a contractual tool, right? It's not a public mechanism tool like how court litigations work. Although it is regulated, it's heavily regulated, but it is still invoked contractually. I mean, there is no act which says that, yeah, just because you fall into a dispute, this act says you can go to arbitration. It's not like that. That's not how it functions. So if you and me enter into a contract, let's say a sale of goods agreement, and we mention that, look, you're sitting in India, I am sitting in London, and litigating in Indian courts or in English courts is not feasible for both of us. And it is quite time taking. I cannot fly in, you cannot fly in and out. So both parties sit and decide, okay, we can do one thing. Singapore it's quite common, and it's in the center for both of us. Let's just make Singapore as the seat of the arbitration, and let's make an arbitration clause. So instead of going to the courts, let's add an arbitration clause in our contracts. So there are it's quite common to see in most of the international contracts which contain an arbitration clause. So like I said, 90% of international commercial contracts contain an arbitration clause. And it's quite popular from what it was about a couple of decades back. It's become much more popular as a form of dispute resolution. And just for your information, like a fun fact here, arbitration as a procedure is not something new, or it's not a 20th or a 21st century concept. It's quite old. I mean, there have been various forms of arbitration if you historically see it. Just one small example, if anyone's keen on looking it up, you can have a basic Google search on Lex Mercatoria, or the law of the merchants, how in the 18th century, 18th and 19th centuries, European traders had their own set of regulations and had their own body to resolve disputes among themselves. So this is an example which shows that arbitration has been prevalent among the commercial players in the society. Can we move on to the next slide, sir? Just quickly go. Yeah, this is a small exercise. I request all of you to participate in this because it's quite, so this stage of understanding is quite important, because after this introductory stage, wherever you learn arbitration, it just gets complex. So understanding this that bit of the basics of arbitration is quite important as to how it is derived and how you look at it is your fundamental, that's your base. And then after that, you can, on your own personal interest or wherever you go and study, you can develop on this. So this exercise is based on that. You can come to different answers with this exercise. Let me just introduce this to you. So you have a client who's a large apparel manufacturing company, has forwarded you a request of arbitration. So let's just imagine all of us are big arbitration lawyers operating in different parts of the world, and they've requested and forwarded a request for arbitration and asking you to simply advise as to what to do. You have no knowledge of this underlying dispute. You don't know what the manufacturing company has entered into. So how will you approach this? Just for instance, like, what will you ask your client? So what is your thought at the first instance? So at this stage, what do you think will you ask from the client?
Are they agreed
So the
upon
contract.
extension in contract for
Right?
the, and then
Yeah.
next is like the issue, like if yes, then the issue, like what happened, the dispute between the parties,
Correct?
then the law, like the approaching the other party.
Right. These
So
are
firstly, we have to see whether there is a arbitration clause in the contract as well. So if there is an arbitration clause, then we can only approach for arbitration. If not, then there is no other way.
correct. Absolutely. So these are a few factors that you will look into. Primarily, like all of you have said, and in the chat box, Himanshu, Ritu, and Nikita have said that these are clauses in contracts. So you would basically want to see what contract it is. And then, I'm sorry, I don't remember who spoke, but like one of you pointed out, you want to know who is the party who sent the request for arbitration, which jurisdiction that request is coming from, and what is your client getting involved in here. So these are the primary things you would want to ask your client. And then you would want to order for your client to give you the contract so that you can further advise them on that. So this exercise basically tells you that arbitration is primarily contractual. Everything that happens is on that one particular clause that you fit in your contract. And it is very important that that clause is structured well. Because if that clause goes wrong, everything can go wrong. I mean, at the very beginning, your arbitration can fail, and you will be stuck with a number of litigations and arbitration proceedings at the same time if your arbitration clause is not well drafted. So it's very important to make sure that the arbitration clause is quite clear and you understand, and both the parties understand what they've agreed into. So just for an example, I am in the chat box pasting a sample arbitration clause. So this is an LCIA, which is the London Court of International Arbitration sample clause. Just have a quick look at it whenever throughout this presentation. And this is one of the most efficient forms of having an arbitration clause. So if most of you have thought that it's quite complex and all of that, by reading this clause, you can see it's quite simple. So the more clear you are between the parties, the more clear you are with your lawyers and the arbitrators, the more efficient the arbitration process. The most cost effective it is, the faster it is. Can we move on to the next slide? Yeah, I'll just take Sanjana's question here. So if the parties pursue mediation or conciliation as a method to resolve the dispute, but they're not satisfied with it, so will the court consider the points which the mediator has given while deciding the matter? No, Sanjana, the court won't consider the points. Like I said, it's because the whole process is not binding and it's not enforceable. So the court is not bound to take it, but there have been cases where counsels or like lawyers or parties have used these proceedings as examples of proceedings of mediation or conciliation and even arbitration to persuade. It has a persuasive value, definitely. The court will see that, yes, these parties are litigious. They don't really want to come to a conclusion. They really want to fight it out. It's an ego battle for them. So these small aspects of parties and aspects of a dispute can be easily figured out by courts by looking that these parties have already entered into ADR mechanisms, but they couldn't resolve it. So it does definitely persuade the court, but the court is not bound, or it is not, binding on the courts or enforceable at the court level. I hope that answers your question. Then coming to the main point, international commercial arbitration. I think that's why we are all here today. So why do you think international as a connotation is attached to it? Anyone on that quickly?
So the jurisdiction of the parties which are involved in the dispute, like it has to be an international company or something too.
Yeah, that's pretty much right. So basically, you can figure out, or international commercial arbitration stands out because it's not domestic, right? Because there is a sense of international element to it, because it transcends national boundaries, either because one of the parties is international, one of the parties is foreign, or the corporation who you're dealing with is foreign. The cause of action is taking place elsewhere. So this marks the difference between arbitrations that are purely domestic and arbitrations that are international. And understanding this difference is quite important in an Indian context, because the Indian Arbitration and Conciliation Act 1996, it makes a clear distinction between international and domestic arbitrations. And it's only when you make a clear distinction between these two aspects, you will know how much of the act is applicable to it. So, like I've put it in the slide, Section 21F of the Indian Arbitration Act defines international commercial arbitration. So the main elements of that is either of the parties has to be a foreign national or a foreign resident and is a foreign body corporate. So can be an Indian party and a foreign party arbitrating in India, and that can also be considered as international commercial arbitration. So it's not necessary that in case of international commercial arbitration, in an Indian context, it's not necessary that the seat has to be somewhere abroad. That was the case a few years back, but it is being clarified in the Act now that even if the seat is in India, it can be foreign arbitration.
Microphone
Quickly coming to the next slide, institution versus ad hoc arbitration. So institutional
Your disk
arbitration.
is almost full.
Sorry, I think someone's mic is turned on, kind of disturbing the lecture. Request you to turn off your mics.
Sanjana Sabra has left the meeting.
Yeah. So institutional arbitration is something, it's quite, like, I mean, it's very important to understand the distinction that arbitration can be, these are the two broad categories or types of arbitration as such. Where an arbitration can be institutional, the arbitration can be ad hoc. So
कंगना इसकी साउंड कर दे,
the institutional
इसकी साउंड
arbitration,
करना,
institutional arbitration is
इसकी साउंड करना,
where parties is
इसकी
within the
साउंड
clause
करना,
mentioned
मैं
that
ऐसे ही करते हैं हम.
can somebody mute his mic or something? I'm losing my track of thought. I'm sorry about that. Institutional arbitration is one in which
इसे
a
म्यूट कर
specialized
दे.
institution intervenes, right?
देखो.
So let's just say if you and me enter into an arbitration agreement and say that we will arbitrate according to LCIA rules. Like if you've read the arbitration clause I've posted in the chat box, it says the arbitration under the LCIA rules, which rules are deemed to be incorporated by reference into this clause. So by mentioning LCIA in your arbitration clause, you kind of nudge this institution to take up your arbitration. So you kind of agree, both the parties agree that yes, we will go to LCIA for arbitration. So what are these? Who are these institutions? What do they do? I mean, these institutions are set up. They are basically they kind of facilitate the functioning of arbitration. So the most famous ones are the London Court of International Arbitration. The most reputed one is the International Chamber of Commerce. Then you have SIAC, which over the past couple of years has been very efficient. And believe me or not, there are approximately 1,200 institutions across the world who take up arbitration. I think in India we have the Mumbai International Arbitration Center. There are a couple of them in Delhi, which are quite good. So why do you think parties opt for institutional arbitration? It's quite distinct, institutional and ad hoc, the whole process. It's not just fancy buildings or being in a fancy city like London. It has more advantages to it than the whole glorification about it. So these institutions have pre-established rules. So there are LCIA rules, and if you Google them, they're quite brief. They're about a 10-page rule book, and they cover everything about arbitration as to how your process is to be conducted, how much time do the parties have to refer to arbitration, how many arbitrators can be appointed, who can be appointed. So all of these are pre-established rules that the parties agree to before they enter into an arbitration. So these established rules kind of facilitate the process and they make the process quite faster, simpler, easier. So you don't really have to sit and decide as to, we will have one arbitrator. Then the other party will say, no, we will have 3 arbitrators. And you will say, no, I don't want the arbitration to take place in this way. So by the time you come to a consensus with the opposite party, you lost time, you've lost money. That's why you go to these institutions, because they have a fixed route. You have to follow that, or there's no other option. Then another advantage of institutional arbitration is that they have a list of qualified arbitrators. So for example, if you and me enter into a sale of goods dispute, a contractual dispute, and both of us don't know anything about arbitration, who do we look at? Where do we see who's going to arbitrate a dispute? And that's why you go to these institutions, because they have everything set up for you. All you have to do is pay a fee to them, and they administer the whole process of arbitration. Then it provides assistance. Basically, arbitrators are quite busy in themselves, and the parties are quite busy. The lawyers are quite busy. So who's going to do all the administrative clerical work? Because if 2 parties are flying out from 2 different countries and coming to the seat of the arbitration, let's say London or Paris or wherever, there is a lot required, right? You have to fix meetings, you have to book the conference room, you have to arrange the lunch or dinner, you have to arrange that both the parties sit on time. So all these small things take a lot of time, and people don't have time and money for that. That's when these institutions help them. They have clerks, they have administrators who help them throughout the process for a nominal fee. Uh, Between institutional and ad hoc, I would say, as of the moment, statistics say that institutional arbitration is much more prevalent and famous than ad hoc, and much more preferred as well. Next, I'll be talking about ad hoc. Can we move on to the next slide, please? Yeah. So an ad hoc arbitration is one which is obvious, right? It's not administered by an institution. It's more like you and me decide, okay, let's just book the Taj next to our office. Let's just appoint these two retired judges that we know, and that's how we can start the arbitration process. It's less formalized, but it can get quite complex because there is no institution involved. There are no fixed rules involved. So it depends on the parties on what they decide. So the parties decide, okay, fine, one arbitrator, and if they come to a consensus, then one arbitrator. Then if the parties decide, yes, both of us, have seen this judge on TV. He recently retired. He's doing arbitration. Let's appoint him as an arbitrator. They appoint him as an arbitrator. Both the parties think, okay, I feel instead of going to Singapore, which is quite expensive, let's just head to Maldives, let's just book a hotel and a conference room there and fly out in there. That's when the ad hoc process comes in because you kind of tailor everything to your needs. The parties will have to determine all aspects by themselves. And that's when the procedure becomes complicated, right? So this can be quite contradicting because there have been arguments and there are like valid arguments saying that ad hoc arbitrations can be more effective because you can tailor your procedures. You're not bound by LCIA or ICC rules to follow to pay them that high cost that you'll be paying. You can say that my dispute is quite small. I don't need 5 hearings a month. I don't need to fly to London or Paris 5 times a year. My dispute can be solved in 3 or 4 hearings. So you can kind of tailor your arbitration process, and that's possible in an ad hoc setting where it can get more quite cost effective, and then you decide which laws will be applicable. The parties amicably decide that. But like I said, that's not really the case because when you're in a dispute with the other party, you're quite aggressive, right? You don't want to really comply with everything he says. There's like an aggression there's a tension between two parties. So why would you agree to something he says? You would definitely want them to be in trouble, right? So that's the bad faith or the bad intention comes in, and then the whole process of arbitration fades away. So I hope you understood like a very, like on a basic level as to what is the difference between institution and ad hoc. Do you have any questions on this yet? Okay, I think no one has a question. Can we move on to the next slide, sir? Yeah. So it's quite important to see that in an international commercial arbitration, what are the laws? I mean, who calls it international commercial arbitration? And if it's international commercial, if I'm from India and you're, let's say, from Sri Lanka, and we're both arbitrating, and once the arbitration is done, fine, done. And then what? What happens after that? You go back to your country, you forget about it. Who's going to handle all this? Who's going to keep this transnational body together? Because it's like a cloud, right? It's floating all over the place. It's happening in Paris, it's happening in London, and parties from all over the world. I mean, they're all over the world flying around here and there, trying to resolve their disputes. So who's trying to keep this together? And for that, it's very important to see the legislations, the rules behind this. This slide kind of gives a very clear picture as to the main laws and rules on international arbitration, international commercial arbitration. The first one, which I think is the backbone, there could be contrary arguments to that as well. It's called the New York Convention. very basically, but the full form is the UN Convention on the Recognition and Enforcement of Foreign Arbitral Awards, which is termed New York Convention because it was signed in New York, and the convention took place in New York. So this is a 2-page, just like 2 sides, that's it, and 7 articles which controls arbitration agreements and arbitration awards. This is one of the best international conventions I've come across, and since 1958, it's been working efficiently. So it has about, I'll jump into that in the next slide. So just come to so there are European Convention of International Commercial Arbitration. So this kind of operates and tries to hold, and it has regulation on the European states within the EU. Then after all this, you look at the national legislations. I know you, like, for example, if you're an Indian party and if you go for an arbitration, and let's just say that the award is against you, so you know the party is coming to India to get all the costs and to enforce the award. So where do you look at then? You look at the Indian Arbitration Act, right? Because within India, within domestically there, the Indian Arbitration Act will kind of govern the enforcement of the award. So it's quite necessary to understand as to why is this so consistent now? Like, I mean, why hasn't this fallen apart? Because it could be a matter of public policy. It could be a matter of it could be a matter of security and secularity for states. Let's say an English arbitrator sitting in London says that this Indian arbitrator or this Indian company, let's just take BHEL, which is a public state entity, is blatantly wrong, is doing wrong to consumers, doing this, doing that. So it kind of is a shot. There are shots fired against the state, right? So why do you think the Indian courts will entertain such an award? That's when there is a need for comity among states, right? Because when you've agreed to sign a convention or a treaty, you kind of come to a consensus. So there are a comity of states. All the states agree that yes, we want to promote or we want to accept arbitration because it has a lot of advantages. Ease of doing business, you attract foreign investments. There are so many more economical advantages to arbitration, which is kind of favored nations to come together and form a comity. And that's when the UNCITRAL model law of international commercial arbitration comes into picture. So this model law lays down standards, and on these standards, various national laws have been adopted. So after this seminar, if you do like a very basic Google search on UNCITRAL and Indian Arbitration Act, you can see that the Indian Arbitration Act is basically a derivation from the UNCITRAL model law. Most of the clauses have been adopted from the UNCITRAL model law. So coming back to the point that you not only have to rely on international treaties, but also your national legislations. And thirdly, there are rules, like I mentioned, institutional rules, ICC, LCIA, which kind of govern and administer the arbitration. And lastly, there are also soft laws. Like I said, there are no hard and bound rules on evidence in arbitration. So IBA, which is the International Bar Association, has come up with guidelines to regulate certain matters within the arbitration. So these are the basic laws and rules which you should keep in mind before jumping or studying in arbitration further. Can we move on to the next slide, please? Yeah, like I spoke about, New York Convention is the backbone. I mean, this is what is keeping 160 countries together on arbitration. So basically, New York Convention is focused on, the title is focused on enforcement of foreign arbitral awards, but it also covers arbitration agreements. So this is very important because let's just say you're arbitrating, like I've mentioned earlier, let's just say you're arbitrating somewhere in a different state. What's the value if it cannot be enforced? There's no value to it. You've spent all this money traveling, you've spent all this money appointing arbitrators, but what if you cannot go back to your country, go back to the other person's country and enforce the award? it just becomes futile, right? New York Convention helps you there. It's basically an international treaty which has established rules of enforcement of foreign arbitral awards, and it's unilaterally applicable. So when a dispute comes into place on about enforcement in any national court, and if that country is a signatory and has ratified the New York Convention, basically New York Convention supersedes their national law. So if the national law says that, look, we cannot enforce this, but the New York Convention says if it does not violate your public policy, if it's not a threat to your sovereignty, you have to enforce it without a doubt because you signed the convention. That's what New York Convention does. It kind of holds together the whole arbitration process because ultimately it all boils down to enforcement, right? If your arbitration process is successful, you want to enforce, you want to cash your award soon. That's what the New York Convention helps you in. And I think it's the backbone of international commercial arbitration. Next slide, please, sir. Yeah. I am sure arbitration is quite complex. Okay, so I'm sure most of you must be confused because it's quite haywired. And once you start unpacking things, right, even on a very introductory level that we're doing it today, you start going from point A to the last point very quickly, and you don't realize that when did you where did you start and where did you end? Like as a student myself, I can understand that the very first time or the very first few times that I read or learnt about arbitration, it was quite confusing because people were randomly talking about first arbitration as ADR, arbitration agreement, contractual, then suddenly from somewhere award comes in, suddenly from somewhere enforcement comes in. So just to make this concise for you, to make it much more clearer, this picture shows you a step-by-step process of how arbitration works, not only in an international setting, but also in a normal setting. So what happens, like we all discussed that it's contractual. So you refer to arbitration, you make your arbitration clause, and then if it's a dispute, you rely on the clause to refer it to arbitration. Then what happens? The opposite party responds, yes, we are into a dispute, let's go for arbitration. Then there is appointment of an arbitrator, or the institution appoints it for you. So let's just say if you've chosen LCIA or if you've adopted ad hoc, both of you have to sit down and say that, okay, now that we've agreed to arbitrate our matter, we want to appoint someone who's going to hear it, right? Then you appoint, you give a certain number of days. Let's just say 30 days to appoint your arbitrators. After that, the institution comes in. So you do that. Then after appointment, you have a preliminary hearing where the arbitrator sits. So this is also called case management hearing. It's very important. It's very common to see in common law and other Western countries that case management hearings are very, very important, where the arbitrator or the judge in a litigation sense sits with you and decides as to how many hearings will this take? What is the time frame we're looking at here? What is the evidence that we're looking at here? When are you going to exchange your documents? That's when you come to the next stage as to submission of documents. So both of you agree as to, okay, party A, party B agreed on an arbitrator. Now we have to sit down together, make our submissions, give the evidence. So we set a time frame, like I said, let's just say 45 days, 30 days to submit your documents. Then they come up with their documents. And within these stages, there are quite a lot of intricacies in it. I don't want to jump into that right now because very basic level, you get confused if I talk about all that. Then after submission of documents, it's basically like you can see, it's much more like a court process, right? But it's just very, it's not formal. You can decide as to the time frame. You can decide when to submit. It's at your convenience. It's not at the convenience of the court. That's the advantage here. Then you go ahead with hearings. You can decide as to you want week-long hearings or you want hearings once a month. It all depends on you. Within the hearings, the arbitrators or the tribunal will see that there is all the documents are clear. You're keeping everything on the desk before you sit to argue your matter. There's sufficient evidence. There are all the additional documents received by the respondent. All of that is done. Then the hearings take place, preliminary hearings take place, then the cross-examination takes place, and then final hearing, obviously, like how it is done in courts. And then the arbitration tribunal or the arbitrators, they pass an award. So all this can be done within a very strict time frame. All this can be relaxed as well. So that's where the whole tailoring comes in. I mean, you choose your set of laws, you choose your set of regulations, you choose uh, how you want to conduct the procedure. That's the whole party autonomy of arbitration, because it's not on the whims and fancies of the arbitrators or of the institution. It's on the whims and fancies of the parties. If both of them agree, they think that the arbitration should finish in 90 days, it should finish in 90 days. So that's the advantage of it. And in an international commercial setting, at every stage, even before you refer to the arbitration and throughout the process of arbitration, and after your awards are published, there are a lot of complexities coming, a lot of problems coming. And that's where the whole concept of international arbitration has expanded to an extent that it is an industry in itself now. Because each stage has such issues that you can really, play with the process to tailor your needs. You can, if one thing goes wrong, the whole system becomes futile and you lose out money. And then you're suddenly at a stage where you don't know what to do. It's quite important to, as a student, to understand intricacies in each level, even before you start your arbitration and after you finish your arbitration. So for now, I think I've kind of, given you an essence of what international arbitration is, what ad hoc institution is, what arbitration is. I think we can jump to questions now.
Thank you, sir. It was a wonderful session. Now the session is open for questions, and you can drop your questions in the chat box.
Questions
By
and
the
feedback, anything. If the students feel that it was useless, they can say it's useless.
There is one question from Atharva Tokekar. Are
Okay.
two or more people can be mediator or arbitrator?
Sorry, you didn't see the chat box.
Yes, are
Is
two
it
or
on
more
the chat
people.
box? Sorry, can you repeat that question, please?
Are two or more people can be mediator or arbitrator
Yeah, like I said,
at the same time?
if you go back to the initial part of this lecture where I explained you ADR mechanisms. So there are pre-ADR mechanisms, right? So there can be contracts which say we have to mediate first and then arbitrate, or we have to negotiate first and then arbitrate. So in that setting, what happens is the parties can be wise enough to save time and money. They can choose the same people to mediate, negotiate, and arbitrate. So if the mediation negotiation fails, so the same retired judge or the same senior arbitrators can sit down and be like, okay, guys, let's come to the table, let's talk, let's sort your issues now. But we are not going to pass an order here for you. But if you fail to do that in 30 days, we will proceed to arbitration. And then it's on us to pass an award. I hope that answers your question. There are a few questions in the chat box. I'll take that.
Can I read for you, sir? Can I read it
Yeah,
for you?
fine. I can do that as well.
Gayatri Chanchalani, she wanted to ask, sir, since it's United Nations Convention, that means that it isn't binding on any country per se. So does this leave such a question up to the challenge? And if so, where would it be challenged?
Yeah. So if you would have seen my slide on New York Convention, it says that 160 countries are signatories to it, right? So when countries join United Nations, when they're a part of such a body, and when they sign such a convention, it is automatically binding upon them. So there is no scope of challenging the convention as such. if you had to challenge it, I mean, I don't know I don't know of any case where they've challenged the New York Convention as such. It could be probably discussed in a resolution in the General Assembly of United Nations, probably, if the convention is faulty or if countries want to challenge it. But once you sign it and once you ratify it, it's binding on you.
Sir, one more questions from Ritu Jaiswal. How can we build an arbitration profile during law college?
Yeah, I'm going to come to that. I mean, towards the end. But if you want me to address that right now, I can do that as well. So, for now, you have to understand. I think, as Sukwinder sir had mentioned to me, that most of the students are in their second year. It's quite good to think quite early in this particular industry. So, there are quite a lot of courses, quite a lot to read. So, firstly, to understand the basics, right? What arbitration is, like what we've discussed today. And then learning it piecemeal, I feel, will kind of help you. So I'm posting this in the chat box. You can all look at these courses and reading materials to kind of have a further guidance as to how to go about arbitration as an ADR or how to learn about it. And to build a profile, I would say, firstly, read up. Okay, read up a lot on it. I will recommend a textbook as well. I'm sure this can be found on. So this is really the Bible of international arbitration. That's what people say, and I believe too. It's Redfern and Hunter on international arbitration. It's available on e-library platforms. So if you go to JSTOR or Hain Online from your e-library, you can access the book online. So you don't need to buy it, and it's quite it's quite explained in a very piecemeal manner in the book, and so that's a student edition. It's quite simply explained in simple language, not much jargon. Anyone who reads it like a novel can understand it. And to build an arbitration profile, look up institutions like CIARB, Chartered Institute of Arbitrators, or Mumbai International Arbitration Centers. They have student memberships which are free of cost. I would say go to their websites, sign up for student memberships, sign up on their newsletter so that you're informed of what is happening, of the courses, you're informed of what seminars, webinars are taking place, you're informed of who are the senior arbitrators in the industry. So just by signing up a student member, you kind of have your foot in already. I hope that answers the question.
Sir, one
Uh,
last question.
can we take a next other question?
Sir, yes. How long does the arbitration last?
Yeah.
Isha Pandey wanted to ask.
Yeah. So in an international setting, that completely depends on which rules you choose. So in an ICC arbitration, typically lasts for 120 days from the beginning till the end. But the whole thing here is, again, like I said, it's party autonomy, right? You can't just force them and say that, okay, you just got 120 days, finish it. But since the very beginning till the last, there have been provisions, or there are provisions provided to the parties to seek extensions at seek extensions not only on the discretion of arbitrators but also on discretion of rules. So even if the arbitrators think that you're just buying time, you're just wasting time, if the rules say that yes, you will get a 30-day extension, you will get it nevertheless. It's not on their discretion. So typically it lasts for 120 days and extends max to max about 180 days, not more than that, in an efficient arbitration. But arbitrations generally also tend to go longer than that because of the intricacies that come up and things that are involved in a commercial, in a complex commercial transaction. And what are the arbitrator's primary duties? Primary duties, I think, firstly, after you appoint the arbitrator, like the first thing they have to do is get the parties to a consensus on the case management, saying that, look, you have got 30 days to submit your documents. Don't delay. Don't act childish. Be cooperative. That's the first steps. Then arbitrators kind of, tend the parties to lean towards cooperating on and doing things on time. That's when time efficiency and the process becomes expedite because arbitrations force them to do that. Thirdly, arbitrator's job, the most important job, is to read up, to see what the matter is about, to examine the documents. And believe me or not, arbitrators charge more for reading documents than for the hearing. Because if you send them like a bunch of documents and they have to go through all of that, they're going to charge you a load of money for it. And they do that very well. And then after that comes to the hearing stage where they hear both the parties. They kind of govern the cross-examination as well. And thirdly, they adjudicate on the matter by passing